HOA is now $950 per month. I have all my stuff on auto pay because I ain't trying to remember like where my money got. First couple payments, then I peeped what was going on.
Okay. Good afternoon, everyone.
Good afternoon, Justice Cumberbatch.
Good afternoon, Justice Cumberbatch.
Hi, good afternoon, Chief. Good afternoon, Justice Felice. Is Justice Yorke Suhan on? Is she on?
Yes. Yes, I am. Are you hearing me?
Yes, I'm
And
hearing you.
Are you seeing me? I'm here. My camera is
I'm
on.
seeing you. I'm seeing you. So we will have the presentation now from Justice Alice Yorke Suhan, sorry.
Suhan,
Justice
yes.
of Appeal from Trinidad and Tobago. And she will address us on judge alone trials, no case submissions, and summations. So over to you now, Judge.
Thank you, Mr. Chairman. Thank you, Chief Justice, for giving me this opportunity to share with your newly appointed judges and your judiciary on these topics. Beginning with judge alone trials, I must begin by saying that this is a very extensive topic, but having regard to the time limits, I will not be able to address every aspect of it. What I'm going to do is an overview of your legislation and how it ought to be applied. And then I'm going to look at some of the challenges that come with judge alone trials. But there are two very important aspects that I hope sometime in the future we might have a chance to look at. And that is, as a judge sitting alone without a jury, how are you going to assess the credibility of the witnesses? Because you are now taking over the role of the jury. And so you now have to assess credibility. And how are you going to do so? But that is a quite an extensive discussion, along with writing the judgments as a judge alone, because you're not doing a summing up, a summing up, you're writing the actual decision. And then how does the Court of Appeal approach judge alone trials? What is the Court of Appeal looking for? So those are some other areas, regrettably, that we are not going to be able to touch at all today, but maybe some other time in the future. So I'm going to look firstly, for the purposes of this afternoon, on firstly at the overview of a judge alone trial. Next slide. The object of this session is to allow participants to have an appreciation of the provisions of the Indictable Procedure Act, Chapter 96, especially sections 65A to E, and to be able to apply these provisions when conducting judge alone trials. Now, first of all, we are not alone in doing judge alone trials. There are many, many jurisdictions who have followed on, and some of them have been doing judge alone trials for many, many years now. So, for example, in South Africa, because of their apartheid situation, they began judge alone trials way back in 1969. But recently, with the pandemic, a lot of jurisdictions hustled legislation through their parliament in order to be able to deal with the COVID lockdown and not interfere with the criminal justice, with the flow of criminal justice in their respective jurisdictions. And so you had a lot of emergency bills being passed during that time. In Northern Ireland, judge alone trials began since 1970, and that was due to the civil troubles that they were experiencing and still experiencing there with terrorism and religious conflicts and so on. And in New South Wales in Australia, way back in 2009, judge alone trials began. And now it is increasing at an extremely fast rate of at least 25% of their trials in that jurisdiction being conducted by judge alone. On the contrary, in other jurisdictions like China and South Korea, you have the opposite movement. What you have are those jurisdictions trying now to come to jury trials to, to fully establish the independence and impartiality of their respective judicial systems. Now, like everything else that is new, there are the skeptics. So there are those who do not endorse judge alone trials at all, but who prefer to hold on to the old jury trial only because it has been there for so long and we do not want to touch it. We will not touch it because it has been working for 800 years in the United Kingdom, England and Wales. And so the Criminal Bar Association put up some resistance when they sought to make the move or the transition towards judge alone trials. And with everything that is new, it comes with that kind of skepticism. It comes with its own challenges. It comes with those who would fight until they are tired. And of course, where these changes are needed and where those who are pushing those changes are bent on doing so in order to improve the system, and the others lose out, they get tired, they fall by the way, and eventually they have to succumb. And so this trend is exactly what happened in our Caribbean jurisdictions. In Belize, I understand that you have been doing jury trials since 2011. If I'm wrong, please correct me. Since 2011. And in looking at your legislation, judge alone, sorry. And in looking at your legislation, the provisions were quite short and to the point. And in comparing your provisions with other jurisdictions, there is a lot that has not been stated in your jurisdiction. Not particularly to your detriment, but you do have short workable provisions. An important element that is missing is that in most jurisdictions, the accused has the choice as to whether he wants a jury trial or a judge alone trial, simply because he has a right to a jury trial under the various constitutional provisions. And that right cannot be easily taken away from him. But if he agrees, he can waive that right. So hence the reason for the consent. But in your jurisdiction, I noticed that there is no provision for election by the accused. Next slide. Now, beginning with your section, beginning with a definition of what jury trial is, it's simply a trial in which judge alone trial, sorry. It's simply a trial with a judge alone who decides both questions of law and fact. Now, section 65 sets out the power, the authority, and the jurisdiction of the judge who is conducting a judge alone trial. In some jurisdictions, a judge alone trial is known as a bench trial or a waiver trial or a non-jury trial. And so section 65D, which is common to all the jurisdictions that have jury judge alone trials, it sets out the powers of the judge in a judge alone trial. And the judge retains his power of the management of the trial and of the courtroom. And section 65D gives him an additional power. And that additional power is to review the facts of the case and to decide on the case on the issue and to decide the issues which would arise on the questions of fact. So he now has the same power as a jury to decide on the issues of fact as they arise in any particular case. He also has the authority. He did not have the authority before as a judge sitting in a jury trial to deliver a verdict. Now he can do so, and he can find guilt or innocence as the case may be. He also now is empowered with a jurisdiction. And that jurisdiction is that when an accused person is arraigned before a jury, he's put in charge of the jury. And the jury has the jurisdiction to decide on a verdict in relation to the charge. Now the accused is put in the charge of the trial judge. So the trial judge now has jurisdiction to perform the same function that a jury would perform. So section 65D gives the trial judge the power, the authority, and the jurisdiction to try an accused person alone. Now under section 65A sub 2, indictable cases may be tried in your jurisdiction without a jury. And there is a list of the type of cases that can be tried without a jury. In fact, it is mandatory. If I'm wrong, you can correct me, but it seems to me to be mandatory that cases of murder, attempted murder, abetment of murder, conspiracy to commit murder, manslaughter, abduction, and sexual offenses all offenses under the Trafficking in Persons Prohibition Act are all now to be tried by a judge alone. This list was extended, I think it was in 2020. Before it used to just be murder, manslaughter, attempted murder, and so on. But it was extended to include abduction, sexual offenses, and so on in 2020. So these offenses must be tried by a judge alone. Now, there are instances where the prosecution can come to the court and apply for a particular offense not included in the one we have just considered to be tried by a judge alone. And that can happen where in those types, in that particular case, there are attempts to interfere or to tamper with the jury or to interfere or intimidate witnesses and jurors, cases in which a material witness might be afraid or unwilling to give evidence before a jury, cases involving gang elements, and where the complexity and or length of the trial is likely to be burdensome on the jury. So the prosecution can come in cases not considered by the legislation to ask the court for a trial by a judge alone. And it can be done only in these circumstances I've just referred to as set out in section 65B(2) of your Criminal Procedure Act, the amendment to your Criminal Procedure Act. An accused person charged with an offense not within the scope of those offenses contained in section 55A may apply for a judge alone hearing, but only on the basis that he has experienced some pre-trial publicity and it is unlikely that he's going to have a fair trial. So whereas in other jurisdictions like Trinidad and Tobago, Antigua and Bermuda and so on, you have the accused having the election, the choice to say, well, I want to go for a judge alone trial. You don't have that election in Belize, but what you do have is that only in cases where an accused person may have been exposed to pre-trial publicity, he can now come to the court and say, well, I don't think I'll have a fair jury trial, but I would, and in those circumstances, I would like to have a trial by a judge alone. Any applications made either by the prosecution to have a case be heard by a judge alone or by an accused in cases where he may suffer some pretrial publicity that might be adverse to a fair hearing, all such applications must be made in the absence of any jury. So if a jury trial has begun and the jury is present and an application of the sort needs to be made, it must be made in the absence of the jury. In cases of joint trials where you have more than one accused persons being tried, the court must be satisfied that all those persons are consenting to judge alone. If one person is saying, I want a judge alone hearing, but the others say, no, we want to stick with the jury trial, then the court cannot, under section 65B(5), grant the application for that one person. And that is simply because it is going to be complex, where you're going to have two sets of trials. You're going to engage a lot of the resources of the court. It will certainly be most inconvenient to have that kind of thing happening. And more convenient, of course, to have a trial by jury where everyone is tried at the same time. And most importantly, the court wants to ensure fairness, and the court wants to ensure that justice be done at the end of the day. And so it is better achieved if all those persons are tried together. Now, if a judge were to refuse an application to have a judge alone trial, such a decision cannot be appealed against. So judges, you are safe when you make a decision not to have a judge alone trial. You don't have to worry. You don't have to look behind your back to see if the Court of Appeal is coming behind you. There is no right to appeal from such a decision, and that is found in section 65B6 of your provisions. Now, who can appeal? At the end of the day, when the trial is completed, who has the right to appeal? Section 65(3)(c)(3) says that an appeal lies with the accused person who's been convicted, as well as with the prosecution from the decision of the judge given after that person has been convicted or acquitted. So either party has a right to appeal. But of course, as I said earlier, you cannot appeal the decision if the judge gives a decision not to have a judge alone trial. Now, a judge alone trial takes the same form and structure as that of a jury trial, with the obvious exceptions. The main difference is that in a judge alone trial, the judge has to sum up the case to the jury, and it is the jury who will deliver the verdict. Of course, in a judge alone trial, the judge sums up to himself. He speaks to himself. He directs himself in law, and he writes his decision down. So that's the main difference. But there are opening speeches. The prosecution will call their witnesses. The witnesses will be cross-examined by the defense. The prosecution will close its case. The defense may make a no case submission. If that submission is turned down, then the defense is entitled to testify, to call witnesses, to remain silent. Then you have the option to address the court, and then the court gives its decision. Same rules of evidence applies. The judge addresses issues of admissibility that may arise, and the parties may be called upon to make submissions and to argue any legal issues as they may arise. So the structure and form is the same, save and accept for the aspects I've already mentioned. In all jurisdictions, judges sitting alone in criminal trials have a time limit to produce their decision in writing. So in Trinidad and Tobago, we have 14 days. But in your jurisdiction, the legislation says that the judge must deliver the written judgment at the conclusion of the trial or as soon as practicably possible, stating the reasons for the conviction or the acquittal. Now, at the time of the trial, the judge must have his reasons ready to deliver at the time he's given his verdict, or any time as soon as reasonably practical. Now, perhaps you may find that a little demanding, and you who have been doing it will tell me when I ask you, we come to question time in just a few seconds, how you're coping with that kind of pressure to have this decision ready at the time, at the conclusion of the trial. But my own view is that same pressure if you have a jury trial, because you still have to prepare that summing up at the end there. One of the things I love about jury trials is that when it comes to vacation and you finish your last trial, you can close the door to your chambers and you walk away. And you're not like other judges sitting in the other jurisdictions who going home with a box full of work to catch up on writing judgments. So I always welcome jury trials for that reason. It puts you under the pressure, but yet the work is done and you can breathe a sigh of relief when it's over. But we'll discuss that shortly. Now, what about if there's non-compliance by the judge to deliver his judgments within that set period of time? can the conviction be turned over? This was a discussion that was held way back in 1978 in the case of McCleganon, where the court said that the non-compliance is only an irregularity and it does not of itself give a right to the accused to have the verdict set aside or a new trial ordered. The failure to give a reasoned judgment is not an irregularity in the course of the trial, which in itself makes the trial a nullity or renders the verdict suspect. It is in fact a post-verdict requirement and does not affect a trial otherwise valid up to that point. So you can relax. Even if you do not give it on time, it is not going to turn around that decision or turn over that decision that you have made. But of course, everyone should try to conform to the rules and get it done at the time of the conclusion of the trial or shortly, as soon as possible thereafter. Another thing about the decisions that you make and having to prepare it in writing, the learning is that judges should deliver their judgments in judge-alone trials in their final form, and that they should avoid, if at all possible, editing it or making other changes subsequently. And this was held in the case of the Queen and McKeown, 2006, NICA at page 42. Now, because you might feel pressured and rushed, you might have what we call a rough draft. So you use your rough draft, but try to avoid doing too many additions or too many changes subsequently. Because let's face it, if you do a summing up in a jury trial, that summing up is recorded as you speak, and you can't go and change it back. And this this ruling really deals with anyone trying to come back and correct anything that they would have done or said that may not have been correct at that time. So it is important. Don't give it and give it in its final form. And this, of course, calls for a lot of preparation. And once you give it in your final form, you can't be faulted. Now, under section 65E, any reference to a jury when it should be a judge alone, the section 65 simply says, well, that kind of adaptation is provided for. And so if it says jury when it meant judge alone in any reference in law, then that will not be anything fatal. And it should be read in relation to the trial conducted without a jury and by a judge alone. Now, finally, on the overview, I just did a short comparison between a judge alone trial and a jury trial to see what are the benefits. But of course, in jury trials, jury service is really an exercise in democracy, letting the public who has a vested interest in the safety of the community to have a say. And so the jury system has long been held to be the lamp that lights the way. And I'm sure you would have heard that quote coming from Lord Delvin. The jury system is the hallmark of democracy, and you would have also heard that. The jury system also reduces the likelihood that a single person's bias or prejudice could influence the outcome. So it helps to minimize bias. It promotes the independence in the judicial system, and it is tried and tested, and it has worked for over 800 years. And so people expect it to continue to work for another 8 or more hundred, as the case may be, years. Now, judge alone trials have several benefits. They assist in cutting down the caseload because you're moving quicker. It's just you. You don't have to wait until a juror who is sick has to come back out. So you have 2 or 3 days, nothing to do, that kind of thing. It saves time and expense because a lot of time in jury is taken up in jury deliberation, sending the jury upstairs or to the jury room, wherever it may be located in your jurisdiction, when you're dealing with points of law, when you think that something prejudicial might come up. So it saves a lot of time. It is best for complicated cases and high profile cases because the judge who sits would understand how to deal with the complications. It avoids perverse verdicts. And I'm sure you all may have had some experience with perverse verdicts. And now we have to order retrial, more expense, more time, more pressure, more hardship on not only on the accused, but in the entire criminal justice system. It avoids prejudice a jury might brings to its task. Jury vetting is against the principle of a random selection. So how are you going to deal with that? Jurors may be influenced by improper evidence, even if the judge tells them to disregard it. I often used to wonder about that. You tell the jury, well, you've heard so and so. Throw it out of your minds. Don't count it in this case at all. It doesn't apply. And we say, okay, well, we rely on the good sense. But how does that work? Does it really mean that that person is going to throw it out of his mind and not consider it at all? Or is it just all a sham? So that's one of the advantage of judge alone trials. The judge is expected to know how to deal with that kind of prejudice. It guards against juries' exposure to pretrial publicity. It guards against intimidation of jurors. And the judge has to give his reasons for the verdict. But then the jury don't have to give a reason. So for 800 years, we don't know why juries would have given certain verdicts. Have you ever done a trial and you expect the evidence looks so sure and you expect the case to go a certain way, and lo and behold, the jury comes back with a different verdict and you cannot rationalize it at all? And so to avoid that kind of thing happening, a judge alone trial will certainly assist. And so this presentation just gives you an overview of the judge alone trial and the course it should take. Are there any questions before we move on to the challenges that might face you in jury trials? In judge alone trials. I keep saying jury trials, but I'm sorry. Anybody, any questions, any comments? How do you feel about, how have you been coping with having to provide your reasons at the end of the hearing? Has it been demanding, for example?
I'm wondering, Justice Yorke Suhan, whether I could have asked the question, whether there's any judge who has practiced under the system of judge and jury and also has the experience now on their judge alone. If they were to compare those two, which of the two systems from the judge's point of view, from the workload point of view, they prefer? Because I myself only did judge and jury trial because I last did serve in High Court it's over 11 years now, so I've never had experience of judge alone. But I'm just wondering whether there's any person who did both judge alone and as distinct from judge and jury, and how would they say the two compare from the point of view of the workload, the difficulties and the challenges? So I'm not sure whether that preempts your
Yes, that's an excellent question, Chief Justice.
Thank
So we
you.
throw it out to you. Any responses?
I have done both. There are different challenges in when you compare the two. The challenges with a jury trial is that you have the challenges are daily to make sure that no inadmissible evidence reaches the jury, to make sure that nothing prejudicial about the accused gets to the jury. You've got to be like a kind of a judicial police officer
Yes.
during the course of a jury trial. Make sure that no witness utters something that just, slip of the tongue, which I've seen trials had to be stopped just because something stupid somebody said.
Mm-hmm.
And so those are the challenges. And at the end of the day, you prepare the summing up. You make sure that you don't leave out anything. But as you correctly said, after the summing up is over, well, that's it.
Mm-hmm.
With a judge alone trial, however, I find the judge alone trial is that the pressure during the course of the trial is simply not as great as during the course of a jury trial. You know what to ignore and so on. You're a judge. You know what to ignore. Blurt out something, you just disabuse your mind of it. And you concentrate on the admissible evidence. But there is something about judge alone trials here, which I can speak of, that you may not be aware of. In a jury trial, at the close of the case for the Crown and the defense, the lawyers would address you right away. Lawyers would address the jury, right away.
Mm-hmm. Yes.
You find in a judge alone trial, the lawyers always ask for time to go and prepare their addresses. So it's not, I have never done a judge alone trial where at the close of the cases for both the Crown and the defense, the lawyers on both sides get up and say, well, okay, I will start because there are rules here, so who could start first and so on. I will start and start. I've never seen it. They always ask you for time to put everything together. And I feel maybe it's because they know at the end of the day, you're going to go through that evidence with a fine-tooth comb before you arrive at your verdict.
Yes.
It would not depend on their skills as an advocate. It will not depend on brinksmanship, or as a Trinidad would say, bacchanal. There's some lawyers who are very good at swaying the jury and pressing them to do what you never believed they would do. And so it would not depend on their art of advocacy because they know they could preach like Paul, but you have the evidence written down there and you're going to go through it line by line and so on. So they want to prepare themselves for that. Good? So that is what adds to the difficulty that, okay, you give them some time to bring in their written submissions. And then you have something else to read now because you've got to read their written submissions and their authorities. And you're almost put in the position of a civil judge. So those are the only difficulties that I have seen. But after a time, I found ways and means of working around it. And that at the end of the day, all I had to do was to write that part, just look at their submissions. Of course, you must mention their submissions in your decision, what they said, what they didn't say. And you could do everything else in the decision. And then when you get their submissions, you look at their submissions, you apply it to the facts and law, and you write your verdict.
Yeah.
So that's the idea.
Sorry. I'm sorry. Please continue.
No, I'm saying that's the way I do it to cut down on time. In other words, I would start to write the other parts of the decision, like the evidence and so on. I complete that. Whilst the case is in progress, I would complete writing all of that. whatever no case submissions, whatever ruling you've made on the no case submissions, if any were made. And then you wait for them to bring in their submissions. When they bring in their submissions, you deal with that. You apply their submissions to the law, because you know what the law is, whether it is identification or what have you, what are the legal highlights of the case. You know, you identify those highlights, and that you would have done from since case management anyhow. Whether the burning issues in the case, whether the body and soul of the case is a confession statement, identification evidence, or what have you, you know that from case management. So
Okay.
that is the way I try it. It works for me.
Yes, yes. Yes,
I'm
well,
not sure it will work for everybody.
yes, I take your point that the application of case management rules can help, certainly
Yes.
help, yes. And that
Justice
you, I,
Yorke,
I get the impression that you actually prefer judge alone because of the complexities of jury trial. What is your personal preference?
I don't want to tell you toss a coin because we're talking seriously here. But as I said, there are advantages and disadvantages with both sides. There are some
Okay.
cases, quite frankly, I might say this. There are some cases which I don't like to do. Certain types of cases which I just don't like to do. And if I could do them before a jury, fine. Leave it to the
Okay.
jury to make a decision. So there.
Yes. Anybody else would like to share their views? Anyone else?
Justice Pilgrim has his hands up.
Oh, yeah. Sorry. Sorry, Judge.
Good afternoon, Justice Appeal, Suhan.
Good afternoon.
Good to see you.
Good to see you too.
Just in terms of the granular operation, I hear all the evidence, hear the addresses by both sides, and when everything is closed, I would adjourn the matter and giving myself sufficient time to prepare reasons, maybe 2 weeks or 3 weeks, depending on the complexity of the matter, so that you give your judgment, you give your written judgment at the same time, you hand it to the parties and you've at least gotten over the first hurdle of final decision, depending on whether or not you're convicting and so on, because sentencing is a whole other story in terms of reports and the availability of reports and so on. But the way I try to manage it, and well, I'm a very new judge, is to give myself sufficient time to write proper reason, because as you are the judge of the law and the facts, and that is an awesome responsibility, and you have people's lives in your hands. You have to take sufficient time to not only consider the law, but to properly evaluate and analyze the facts, because quite apart from whatever submissions the attorneys make, and you must address that, but you are coming to your own determination on the facts. So you ought to carefully consider it in the context of the ramification, the decision you will ultimately make. In terms of the jury system versus the judge alone, simply a matter of being directed by the law here. I understand the point of having judge alone trials in a small society like Belize, because when I've only been here a few months, it's become readily apparent to me that everybody kind of knows everybody here. And it's maybe a very good thing that you have a system where someone is coming to the country who knows no one, who doesn't have any of the background knowledge and so on of the parties or the controversy and all of that, and can, I think, give the fairest decision. Those were just my comments to the points that you raised, Justice Appeal.
Yes. Thank you very much, Judge. I think those are very valid points. Most of the Caribbean communities are small communities where everybody knows everyone else. So judge alone trials can alleviate a lot of the perceived prejudice in our small communities. All right, if there are no other comments or questions, we'll move on now to consider some of the challenges which face judges in respect of judge alone trials. And it is my hope that at the end of this session, you will all be able to identify those challenges and you'll be able to effectively address them. Right, so let's go on to the first slide. So, next one. The judge alone trials create new judicial functions. Next time. They create new judicial functions. This new role is not prescriptive, it's not selective, and it's not inquisitorial. It is not prescriptive because a judge alone trial does not mean that it is all about the judge alone. It involves other things. It involves parties, litigants, and most a very important facet is the involvement of the public and the public interest in criminal trials. So the judge alone trials judges are not about you alone. It's about all the stakeholders. So you cannot do as you please. The only change from jury trial to judge alone is that there's no jury and you are now deciding on the verdict, but everything else remains the same. And so you're still expected to rule on matters of admissibility, and you're still expected, for example, to extend judicial courtesies. It's not selective because you can't cut short the procedure. While we're all interested in moving the criminal justice system along in attacking the backlog and getting the work done, we cannot in judge alone trials take it upon ourselves to be selective and to cut short any of the procedures. You cannot be selective as to which, for example, which rules of evidence you will follow and which you would not. And it cannot be inquisitorial because you cannot step into the arena and make adverse comments one way or the other. The overriding duty still is and will always be to ensure the fairness of all the parties. You are not held to a lesser standard than if you were trying the case with a jury. You still have to consider the defense adequately and fairly, shutting out all the prejudices as they may arise, safeguarding witnesses, and managing the courtroom. And the overall and overriding task is that you need to ensure that the accused has a fair trial. So the new rule is not prescriptive, not selective, not inquisitorial. What then is the new rule? The new rule involves assessing credibility, writing reasons, self-directing, and the new rule involves transparency. So in respect to assessing credibility, as the judge, you now have to pay closer attention to what the witnesses are saying. And not only to what the witnesses are saying, but how is the witness saying it? You now have to look at motive, plausibility, bias. Instead of talking to others, instead of talking to the jury, you now have to be talking to yourself. Instead of leaving the reasoning to others, you now have to reason yourself. Instead of directing others with respect to care and caution, you now have to exercise care and caution. The challenge really is making those adjustments or becoming accustomed to these new responsibilities. Instead of preparing a summing up where you would talk to the jury so that they could now decide, you are now reasoning it yourself so that you could decide. You have a time within which you must complete your reasoning at the conclusion of the case or as soon as possible thereafter. All these are new changes, and you have to determine how you are going to approach them. So very quickly, with respect to assessing credibility, your challenge now is not only hearing what the witness has said, but now you have to look at the demeanor, but at the same time, guard yourself because demeanor could be misleading. You now have to investigate if there is a motive for lying. You now have to see whether the evidence makes sense for one side or the other. Is it plausible? Is it making sense? You now have to examine inconsistencies. Are they reconcilable? Are there explanations to them? Do I believe those explanations? And most importantly, you have to look at your own self. You have to do a kind of self-examination to ensure that you're not biased at all in any way. And in short, these are the things that are involved when you're assessing credibility. You also have to write reasons. And in writing reasons, you have to prepare them. At the same time, you're hearing all this evidence. You're trying to decipher where the truth lies. And you have to sit down and write reasons. As Justice Pilgrim just shared with us, he would take a couple days when the trial is finished just to make sure he has it down, packed his final form and everything, and then he will do it all together, give his verdict and deliver his reasons. Now, if you were to take excessively long doing this, then judge alone trials is not helping the backlog system, but then you as a judge alone, you're now adding to the backlog and to the difficulties that already exist in the administration of justice. And so the writing of reasons is very, very important. Justice Lucy McCollum from New South Wales wrote an article called Judge Alone Trials, A Judge's Reflections. And it was written for the Judicial College of Victoria on the 13th of May, 2020. And she suggested that in writing a reason, start from the beginning with a very first witness and very first ruling that you have made. Discipline yourself from the outset, because that will allow you now to create a chronological bare bones of a judgment, and those points will serve as a memory prompt when you come to flesh out your reasoning. Be certain to state enough to demonstrate a knowledge of the principles which apply. Try to carve out time after the trial to go on a verdict, meaning taking a few days, just as Justice Pilgrim suggested, to prepare your reasons. And this should be priority. She admonished that judicial officers should not proceed directly to the next case unless you finish your reasons for this one. Because by then, you would have forgotten some of the important things that came out of this trial, because your mind now focus elsewhere. We're only human beings, and we can only work within the limitations that we have. And so don't try to be super judge. Everybody have ambitions. They want to get to the Court of Appeal and the CCJ and everywhere else. But you wouldn't get there unless you do what you do properly. So don't move on and try to bite off half of the cake and eat the whole cake one time. Do what you can and do it well. You have to now be self-directing yourself. Now, one of the things you must be cautious about is giving yourself warnings. And not only thinking about it, but make sure it's there, because the Court of Appeal want to see that you directed yourself about care warnings. You directed yourself that I must examine this evidence carefully because this witness might have an interest to serve. If the Court of Appeal doesn't see it there, then the Court of Appeal concludes that you have not taken that into account. So make sure you direct yourself properly and make sure you include it in your written reasons. Also, there may be defenses that arise out of the evidence which were not pursued by the defense. So, for example, there may be a case involving self-defense and provocation that the defense aiming for full acquittal focus only on self-defense. And so you didn't address provocation at all, but there's evidence there. The burden is on you now, and always was, even in a trial with jury, to show that you have considered it and you direct the jury accordingly. So those are just some of the things that you now have to do. Self-direct, write your reasons, and so on. And most importantly, trials by judge alone really is a transparent type of justice, in the sense that with jury trials for 800 plus years, we still don't know how some juries arrived where they did, because we cannot ask them the reasons for their verdict. But judges now are called upon, the burden is now placed upon them in their written judgments to be transparent. That is to say, how they arrived at their decisions. And so now through judge alone trials, an accused can know whether the reasons why he's found guilty or not. And so with this new rule, we must exercise caution. The next risk that we face is the increased risk of bias. How do we know that the judge was not biased? How is the accused satisfied that the judge is not biased? One of the arguments for jury trial is that there's a less risk of bias because there are 12 persons adjudicating, whereas in judge alone trials, there's only one adjudicator, and so therefore the risk of bias has increased. It was once said that judges have the most intractable bias of all. And what is that? The bias of believing that they are without bias. Although trial judges are specifically trained to compartmentalize and to shield their decisions from their own biases, implicit bias nonetheless seep into the judicial decision making. The judge is trained to write his judgments, and often he writes an excellent judgment, properly assessing credibility, factoring his care and caution warnings, and coming to what may seem to be the right decision. But how do we know that he was not biased? You see, bias is undetectable because his judgment is perfect. However, it may be detected from his treatment of the accused. As you know, when we look at the proceedings, we see the interruptions, we see adverse comments, and so on. But we will never know if he's biased or not unless these things manifest by his comments or interruptions or other means. What if he makes no interruptions, no comments, and he writes a perfect judgment? How do we know that he was not biased? And so it has been discovered that some judges work backwards. They come to their decision first, and then they write the judgment to suit, to fit the decision and the outcome that they want. And so in that way, again, we will never know what if there is anything that influenced the judgment. And so the case of Manzanaro, which my colleague dealt with in detail this morning in his presentation, is relevant to this discussion because Manzanaro, the appellant, was concerned that the judge who heard the voir dire and the judge who made certain findings of credibility against him was the same judge who heard the rest of the trial. And so he felt that there was a transposition of that kind of bias into the trial process itself, and he had not received a fair trial. And so the CCJ warned judges in judge-alone trials where voir dires are conducted to not to carry over his or her deliberations on the main trial any adverse findings on the credibility of the accused or was not properly influenced in arriving at a guilty verdict by evidence that was prejudicial or indicative of the guilt of the accused and not ultimately admitted into evidence. So they warned all of us judges, especially ones who are now doing jury trial, to be careful not to transpose any kind of bias over onto the main trial. But again, how easy is that to do? Again, we are all human beings. We are even born with prejudices because we grew up in a society where there's so many things around us that will turn our minds one way or the other. And so we have to be very, very careful that we put away the prejudices, the biases that we may come up with along the way, especially during the course of the trial. So another reason that would increase the risk would be that of bribery and corruption. In this, the risk of bias in this, in our small Caribbean community, we have had cases within the region where judges have in fact accepted bribes. There's a case of Dragissa and others, a case coming out of Trinidad and Tobago, where a magistrate took a bribe, he took a car, and he took $500,000 in order to compromise his decision with respect to a litigant who appeared before him with gun charges, possession of firearm. And so if that kind of thing is happening, I'm not saying that it is happening in Belize, but I'm saying you can never tell where it can happen, when it can happen. So guard yourself against that kind of thing. Now, corruption doesn't only come in the form of bribery. It also comes in the form of political interference. So you might have politicians who trying to befriend judges so that they can, get a favorable outcome in a particular case and so on. So guard yourself against that kind of thing. In 2016, in the New York State Supreme Court, a certain judge, John Michael Leck, pleaded guilty to receiving bribes and offering false instrument for filing in a court case involving a political operative named Steve Pigeon. The prosecutors alleged that the judge reached an understanding with Pigeon that the judge would engage in an official misconduct which advanced Pigeon's interests. As part of the arrangement, Pigeon helped the relatives of the judge to find employment and to provide the judge with tickets to hockey games, can you imagine? And political fundraiser. So sometimes people compromise their integrity and everything else for things that are really, things have no value. I mean, if you have to compromise your integrity and you're putting yourself at risk to face a jail, you might as well go big. You don't think so? Yeah, it didn't make sense. So this judge apparently liked hockey games and probably wanted prominent seats. So guard yourselves. The next thing that might face you as a challenge in a judge-alone trial could be forum shopping. Now, in cases where, in jurisdiction, where the accused has an election to choose whether he wants to have a judge-alone trial or stick with the trial by jury, he more has a chance to forum shop because he can come up before different courts. He has a time in which to come back with his decision and so on. So he can just, play the game until the right judge comes up before the right judge. But in your jurisdiction, happily, the gap is not so wide. And so in your jurisdiction, the prosecution can make an application for judge alone trials under the circumstances we discussed earlier, where there might be witness tampering, jury tampering, and so on. Witnesses who are threatened to come to court, lengthy and complex cases, and so. And when he comes, he too can try to shop. I don't like Justice Pilgrim, but I like Justice Nanton. So I'll wait until they switch on. So I'll come for an adjournment and so on. So they shop around to get the judge they feel would best suit their interests. But in respect of the accused, he doesn't have so much leeway. He can only come if there's pre-trial publicity to ask for a judge alone hearing. That is the only ground that he can come in. So that's one good thing about your legislation. You've closed the gap to prevent this kind of thing. But is foreign shopping really bad? Is it really a bad thing? The traditional view is that it is terrible and it should be avoided at all costs. The practice is unethical, undesirable, and could amount to an abusive process. But there's a more modern view which says that nothing is wrong for the client to help, for the lawyer to help his client to obtain the most favorable forum. And the lawyer would be failing in his duty if he does not make use of jurisdictional options. And so you have these two schools of thought. But depending on the circumstances, forum shopping may be either good or bad. For forum shopping to be unethical, it must contain an element of unfairness. Forum selection is different from forum shopping. The fact that the accused, for example, could choose a venue is not considered forum shopping. In some jurisdictions, legislation has been passed in order to prevent forum shopping. So in New South Wales, they passed legislation that a date for trial will not be fixed before 28 days. So you only have 28 days notice to know that your matter is coming up. And so this will give you the chance not to try to, to twist and turn too much to try to get the right forum. And so in debating the bill in their parliament, the Attorney General made it clear that this was designed to minimize the risk of a party applying for judge-alone trial on the basis on knowing the identity of the judge. Because some people just don't like some judges, as all of us know. And some people love some judges, as all of us also know. Now, another challenge with judge-alone trials is that it can create the propensity to be lax. Now, judge-alone trials improve the efficiency of the criminal justice as it avoids the need to undertake a lot of various formalities of the jury trial. And so this would include dispensing with the need for empaneling a jury warnings and directions to the jury, morning and afternoon tea breaks, lunch and transport. And if you're going to sequester a jury, well then, the best hotel and a little entertainment in between and so on. Delays in the event of a juror falling ill or discharging for any material necessity, retrials in the event of a hung jury, procedures of tendering evidence that apply to jury trials, and summing up the case to the jury. So all of these things are dispensed with in a judge-alone trial. And of course, to remind you, as I said earlier, there still must be no shortcuts. Follow proper procedure for tendering exhibits, for the admission of confessions, the admission of depositions, etc. So for example, a judge in a jury trial, you were going to have to read the deposition. But a judge alone sitting will say, I'll read it later, proceed. And so you shortcut procedures. So it is important to remember that a criminal trial, whether by a judge or a jury, that the public has a vested interest in justice, and justice must not only be seen to be done, but it must be done. And so members of the public must be able to follow the trial and to understand the proceedings, and that transparency must still be maintained from start to finish in judge-alone trials. And so be very careful when sitting as a judge alone that you try to short circuit some things and create a very lax atmosphere, and then, you know, things slip through the cracks. When the jurors are there, they represent the members of the public, and judges and lawyers and everybody have to be on their best behavior. But when they are absent, the whole courtroom atmosphere becomes lax. Attorneys misbehave more than they can be allowed to in the presence of a jury. And so that might create an institutional, you know, lapse in the proper administration of justice, in following the rules and in keeping the dignity and the decorum, not only of the court, but the entire criminal justice system. Media reporting is another challenge that you might face as a judge alone. Now, judges should not be influenced by media reports in any particular trial. Judge-alone trials by themselves were designed to guard against pre-trial publicity. And so as a judge, you now have to guard your mind about the things you read, the reports of the case that you would see coming out in the newspaper and in the electronic media and so on. And so you still have to protect yourself, because you now are representing not only the judge of the law, but the judge of the facts. And so you try to keep your mind pure from being influenced by media reports. Another challenge of judge-alone trials is the risk of inconsistent approaches. And so some judges may have their own approach, and the way they may approach a judge-alone trial will be different from other judges. And so you run the risk of inconsistent approaches. Like the example I gave earlier, one judge may say, well, let's read the depositions now that I have admitted them into evidence. Another judge might say, I've read it already, or I'll read it later. Let's proceed. Or if you have an exhibit, for example, a firearm, the judge says, let's proceed. I'm going to check it out later. Another judge might say, no, let's deal with it now. Could you put it there and I can examine it and have a look at it? So we have to be consistent in our approaches. And I would suggest that you who do criminal, I don't know how your court is divided. Maybe all the judges do criminal work. Get together, have meetings once a month. That's what we used to do in our time. And arrive at consistent approaches. Talk to each other, share your views, share your concerns, share the challenges, and work it out amongst yourselves. And so the risk of inconsistent approaches can send a wrong message to the public. The judges really don't know what they're doing, you know. They're sitting alone, but look at the confusion. All right, so is that it for this slide? One more. All right. Right, I think we dealt with this issue already as to whether or not you can refuse an application for judge-alone trial, and we said that the prosecution can apply in certain instances, and that if you refuse, there's no appeal line from your refusal. Anything else? That's it? Now, can I develop that a little more? There's one thought that just came to mind. There are some instances where a jury trial may be more appropriate than a judge-alone trial. So, for example, where you have cases with that considers things like reasonableness, objective community standards, negligence, dangerousness, reasonableness, you would really want members of the community to be the better judges of those issues, like in self-defense and provocation and so on. So those cases might be more appropriate for jury trials. But of course, each case would be dependent upon its own facts and circumstances. And so when you have to determine an application as to whether to grant a judge alone trial or not, you must take into account, I think, a relevant factor would be the is it something that needs to be judged by objective community standards? And then if it is, that a judge alone trial would not be the appropriate course. And so I make that suggestion to you. In fact, in New South Wales, they've actually passed legislation saying where the community issues are involved and community standards are required to judge a case.
We are not hearing you, Judge. Judge, if you're hearing us, we are not hearing you. Yes, there is a technical difficulty in Trinidad and Tobago. Yes.
It's on. Can you hear me now?
Yes, Judge, I can hear you now.
Can you hear me now?
Yes.
It's on. Can you hear me now?
Yes.
Okay. All right. So I don't know if you missed anything, but I was just saying when you told me that you were not hearing, I was just wrapping up to see if there are any questions or comments.
Oh, okay. Are there any questions for Judge Suhan?
Any comments, any questions, anyone? What have been your own challenges? Is there anything that I have not addressed that might have been a challenge to you in your sitting in the jurisdiction of judges alone in criminal trials? Is there anything? Is there anything? No questions, no comments. All right.
If there are no questions or comments, I think it's right that I make a general comment. Because I'm not sure whether Justice Appeals Suhan will be here tomorrow. But I wanted to share with you that the judge who was identified to present on this topic had a difficulty which arose on Tuesday. So I called at last resort my dear friend and sister, Justice Appeals Suhan, and said, look, I have a difficulty. I know you're already doing two topics, but with a judge of 26 years of experience and a judicial educator for many years, I knew I could have called on her and say, look, you have to help me. Please, could you also take on judge alone? And she took it on and didn't disappoint her. So I want to say a special thank you, Justice of Appeals Suhan, for your tremendous support and also for your very enlightening presentation on judge alone trial at very short notice, 2 days notice. Thank you very much. That's my comment.
Thank you, Chief Justice. All right, so we'll move straight into the next topic, which is no case submissions. Now, I'm probably preaching to the choir in this one because I'm sure you all are well aware of how to approach no case submissions. Can I inquire, how many of you have actually done criminal trials and have quite some experience, apart from Justice Pilgrim? Everyone? No one? Justice Nanton?
Judge, I was sworn in on September 1st. I have not yet had my own trial. However, I did sit in on a trial that Justice Pilgrim was presiding over. But I have no experience as of today's
Right.
date.
Is this making all sense to you? Is this making
Yes,
sense
yes,
to you?
absolutely.
Yeah. Okay.
It,
Good.
it is definitely because I mean it's a transition in terms of the mandatory judge only trials,
Yeah.
which I believe puts a heightened pressure on the judicial officer now not only presiding over the law but presiding over the facts and having to always I guess draw the line between the two functions because of course presiding over the law is one thing, but when you have to marshal the facts together to give a reasoned judgment that would withstand appellate scrutiny, I think it's and of course to bring justice to the matter also apart from the appellate scrutiny, you know, it's a high and awesome responsibility as Justice Pilgrim mentioned. So, I mean, this has been very helpful for me at least, I can speak for myself, and definitely some many things to consider, especially the points on bias and implicit bias. I think it's something that we always have to check.
Yes. I think that you're on the right course. You know, you have an open mind and you're willing to learn and so on. So once you're on the right course, I'm sure you will do very well. You and your colleagues, I'm sure. All right. So we're going to talk about no case submissions. Oh, somebody has their hand up. I'm sorry.
No, I was just going to say it's very helpful. I'm a civil judge, and it's very helpful because we don't spend time in criminal court, but when the criminal court is perceived as going awry, we sometimes get constitutional challenges. So it's really helpful for us to
Right,
understand the
yes.
procedure and what the expectations are from your perspective. So I'm learning a lot, and I appreciate that.
Yes, I'm happy about that.
If I
No.
may, Judge,
Yeah,
I
sure.
know you were going to move on to no case submissions. It's just a matter of my own curiosity. In terms
Yes.
of when the appeal court is reviewing verdicts on the judge alone trials as opposed to jury trials, do you find that it's an easier or a more difficult task reviewing the judge's reasoning as opposed to their submission to a jury?
That's a very interesting question. You see, a lot of times we don't doubt that the judge knows it. But as I said earlier, it's not there. So the judge knows that he has to approach his evidence with care, but he does not include it in his reasons that I gave myself the care warning in these terms, and I considered that, and so I'm examining the evidence very carefully. So the mistake judges make is that they, because they're now playing this double role, if they have to do it to the jury, mind you, they will give the correct direction, but to themselves, they have it all there and they think that they have said it and they haven't said it. That is one of the biggest challenges in looking at that. But we do have Justice Mohammed and I did a presentation, I think, to the judges in the Eastern Caribbean, right? And here too. And we have a presentation on what is the Court of Appeal looking for in jury trials. So we could share that with you at some point. So no case submissions, what we will begin by trying to find a definition. What really is a no case submission? At the close of the case of the prosecution, if the defendant is represented, usually his counsel will make a submission that there is no case to go to the jury, or if it's a judge alone, the counsel will submit, Judge, there's no case for you to consider. And by that submission, the defendant is seeking an acquittal without having to present his case. He does not want to be called upon to present a case because he thinks that the prosecution has failed to make out a case against him. Next one. So whose responsibility is it to make a no case submission? Is it the prosecution, is it the judge, or is it defense counsel? Well, as I've just said, usually it's defense counsel who would make that type of submission. But if the interest of justice requires it, and the judge notices, and the judge has read the papers, and the case progresses, it reaches to the close of the prosecution's case, and the judge can see it glaringly that there is no evidence upon which I can call upon the accused to answer this case, then justice demands that the judge takes on that responsibility. Even so, the prosecutor, as Minister of Justice, he must know what's in his file. And so he too can take action if it's open and glaring. But usually the task really is defense counsel. Next. Now, when can such a submission be made? We call it at the half-time principle. The half-time principle because it's made at the close of the prosecution's case, which is about halfway through the proceedings. So after the prosecution has called all its evidence, that is the time that no case submissions are usually made. But sometimes they are made at the close of the case for the defense. So for example, after the defendant has given evidence, new information comes up, new evidence is before the court that shows quite clearly that there is no evidence to call upon the accused to answer the case. And in those circumstances, then it can be made at that stage. Occasionally, during the prosecution's case, where the prosecution is proceeding, as I said, the prosecutor is Minister of Justice, knowing what's in his hand, will, during the course of his case, say, well, I can proceed no further. And the judge will call upon defense counsel and say, counsel can't proceed any further. And the judge might say, well, counsel for the accused, what do you have to say? Well, I want to say that there's no case for the accused to answer, and probably amplify on that position. And so it main point is that the prosecution can, the defense makes the submission and they make it at the close of the prosecution's case. But it can be done in the course of the prosecution calling the evidence and also at the time, at the close of the defense. Those are exceptional places, but it's usually done at the close of the case for the prosecution. Now, such a submission is made in the absence of the jury. And when the jury comes back, if the submission is not successful, the judge is not supposed to tell the jury what transpired. The reason is that the judge is the judge of the law when he sits with a jury, and the jurors are the judges of the fact. Matters of law do not concern the jury, so do not engage them in matters of law. You know, in Trinidad, we have a saying, people like to play bush lawyer. And, you know, you might have some of those in the jury who think that they know all the law, and when they hear what the judge is saying about the law, they want to influence the others and take them down the wrong path. So to avoid all of that. An interesting thing happened in the case of Courtofthe, though. The judge faithfully put the jury out during the no case submission. But then when he came back, he proceeded to tell them everything that transpired in their absence. And so that was frowned upon, as you would imagine, by the Privy Council. So case of Courtofthe is a very interesting case and very helpful case about procedures, especially during no case submissions. Now, how would the judge decide? How can he decide if there is a case to answer? I suggest to you that there's a two-limb test that you must apply. And this test comes out of the case of the Queen and Galbraith. So I want to suggest that you take your time to read the case of Queen and Galbraith and to understand the limbs upon which a no case submission can be made. There's also a very recent decision, the case of the state and Curlin George criminal appeal coming out of this jurisdiction, Trinidad and Tobago, in which my learned brother and his colleagues reviewed all the authorities concerning no case submissions and finally put to rest all the other principles that were being applied when deciding on no case submissions, and finally agreed that when hearing a no case submission, the test to be applied would be the test as laid down in the case of the Queen and Galbraith way back in 1981. So I commend the case of Curlin George to you, and also the case of Galbraith. There's a case called Sanjay Chetlal that decided in 1985 by this Court of Appeal. And that case emanated some principles to be applied. And the court in Curlin George held that those principles are no longer to be applied because the judge actually usurps the function of the jury by determining whether the evidence on a whole is manifestly unreliable and so discredited after cross-examination. And so take a look at Curlin George. You don't have time to go through it today, but on your own, I suggest that you have a look at it. So let's look into this two-limb test. Limb 1. Clearly, if there's no evidence at all, you can make a no case submission. No evidence connecting the accused with the offense charge. So for example, in a case of murder, there's absolutely no evidence that he struck the deceased or came into contact with the deceased at all. If that's the case, that's a very extreme example, but just to try to get the message home. Then of course, there's no case to answer, and his counsel can make a submission to that effect. If there's no evidence to prove the essential elements of the offense, then again, a no case submission would be successful. So again, if it's murder, but there's no evidence to show that the accused had an intention to kill or to cause grievous bodily harm to the deceased, that the whole thing really was an accident, then of course he can make a no case submission. But what about if there is some evidence of the essential elements? What about if go back to the slide, there's some evidence of essential elements? What do you do? Then, if there is some evidence taken at face value, establishing the essential elements of the offense, then a no case submission cannot be upheld because there is some evidence. Can you take defense evidence or proposed evidence or the evidence of potential witnesses into account? The answer to that is clearly no. Reason being, the prosecution must prove its case against the accused. The prosecution must prove it beyond reasonable doubt. In this regard, you can see the case of the Queen and C, 2007 EWCA 1862. I think I sent you a list. So that's the first limb. Let's move on to the second limb, which I've divided into two parts. So what about if there is some evidence? So the first thing, if there's some evidence, though not strong, but at first face value, establishing the essential elements, then you need to send the case to the jury. If there is some evidence, but it is tenuous, either because it has inherent weaknesses, it's vague, or it's inconsistent with the other evidence, and the prosecution's evidence taken at its highest is such that a jury properly directed could not properly convict, then there's no duty to stop the case, no duty to uphold the no case submission. So the court is empowered by this limb to consider whether the prosecution's evidence is inherently weak or vague for any sensible person to rely upon it. If the witness undermines his own testimony by conceding uncertainty about certain important points, or if the witness says what he says is manifestly contrary to reason, then the court is entitled to hold that no reasonable jury properly directed could rely on the witness's evidence, and therefore there is no case to answer. So a quick example, there is a robbery. The evidence is from the virtual complainant that a tall, dark man who was very ugly robbed him. And then he comes to court, that's in his depositions, and he comes to court and he says, no, it was a short, stocky, red, handsome man who robbed me. Right away, you can see the inconsistency in his evidence, and it's an important inconsistency. It goes towards the identification of the person who robbed him. And as such, you can see why a judge, because of that weakness, that inherent weakness, why a judge would uphold a no case submission in that regard. Now, what I call B of the second limb says, if, however, the strength or weakness of the prosecution's case depends on the view to be taken of a witness's reliability or other matters within the province of the jury, and on one possible view, there is evidence upon which the jury could properly convict, then the judge has no choice but to reject the submission of no case. So, if there is evidence which requires the jury to consider the witness's reliability, whether you can rely on this witness, but there's the evidence there, then the judge must not stop the case, because it will be a question for the jury to determine. It will be the jury's task and not the judge's task. And if the judge were to step in, he would really be usurping the function of the jury. So those are the two limbs in the case of Galbraith and the case of Curl and George that comprise the tests which you as trial judges must apply when considering no case submissions. Now, following a no case submission, if the submission is upheld, then the judge directs the jury to return a verdict of not guilty. If the submission is upheld on some counts, then the judge will discharge the jury on those counts on the indictment, but the case will proceed where the submission was not successful. If the submission is upheld all in all, then the defendant is entitled to an acquittal, and as I said, the judge will direct the jury to return a verdict of not guilty. If the submission is unsuccessful, however, the trial continues, the judge should give reasons to counsel during the hearing in the absence of the jury for rejecting the submissions. Reasons may be given orally, and the jury must not be informed of the unsuccessful submission. Now, can the prosecution appeal following a successful submission? The answer is yes. In your jurisdiction, the Court of Appeal Act, Chapter 90, Section 49(1)(a) provides that where a person has been tried by an indictment and has been acquitted by the direction of the judge at the close of the prosecution's case, whether in respect of the whole or part of the indictment, the prosecution now has a right to appeal. The prosecution can also appeal the judge's decision to quash an indictment, and also they also have the right to appeal the sentence that may be passed. This is something new in these parts, because years ago, the prosecution had no right to appeal? Can the defense appeal following an unsuccessful submission? Certainly not, but not right away. They have to go through the motions of the rest of the trial. If the defendant is convicted, then a ground of appeal for them at the appellate level can be that the judge was wrong to reject the no case submission. Now, I just want to spend just 2 or 3 minutes making some special references in cases of identification, confession, and circumstantial evidence with respect to no case submissions. And so I'm sure you're all familiar with the case of Turnbull and identification cases. And of course, the principle that if the quality of the visual identification is poor and there is no other evidence to support it, then the judge ought to stop the case for the jury. And we all know the principles laid down in Turnbull, that the court must examine the circumstances in which the identification came to be made, and the court must examine them carefully. The length of time for the observation, the distance the observer was from the perpetrator, what was the lighting, was anything impeding the observation, and so on. Were there any material discrepancies in the description given to the police and the actual appearance of the defendant? So we know all these factors that will be taken into account in Turnbull. So in identification cases, it's very important that if the evidence is poor and there is no other evidence to support it, for example, a confession statement, then the judge ought to stop the case. So I commend that approach to you. Then with respect to confession cases, if the prosecution case depends only on a confession statement, but there's evidence that the defendant is suffering from a significant degree of mental handicap, and the confessions were unconvincing to the point where the jury properly directed could not properly convict on them, then again, the judge must stop the case. So in the case of the Queen and Mackenzie, this appellant was charged for killing a woman 86 years old. And the only thing the prosecution had against him were some confessions. He confessed to killing 12 other people, none of which the Crown believed he had committed. And the medical evidence given was that he was detained in a secure hospital for a number of years. And he loved it so much, he wanted to stay there. And that was the reason he made up all these 12 killings that he did. He made up evidence, he confessed to the killing and so on, because he loved the hospital. He didn't want to come out of it. And so in this case, it was clear that these confessions, that a no case submission would have prevented the case from going further and would have been the most appropriate approach for both the prosecution and the defense at halftime. So in cases of confession, you have to be very careful. Is this a case in which the person has a degree of mental handicap? If he does not have a degree of mental handicap, but there is some other reason, for example, the confession is full of a lot of lies. So he gives his wrong address. He gives a lot of gory details of the killing, which the forensic people say never happened, and so on. Then these are things that need to be examined carefully in relation to a confession. Once it's the only evidence, then the case ought to be stopped. What about no case submissions and circumstantial evidence? What is the test you must apply in those particular circumstances? Could a reasonable jury properly directed conclude that the defendant, is guilty? Could a reasonable jury on one view properly draw the inferences contended for by the prosecution? Now, remember, judges, that your concern that a guilty verdict may be set aside at the Court of Appeal as being unsafe is not really your concern. When you sit to judge a case, whether it's before a jury or as a judge alone, remember that you are not judging for the Court of Appeal. That's one of the things that the factors that you may want to consider, but it's not the main thing. All right. So we will talk about that when we come to talk about summons up in a moment. But remember, you are judging the case for the litigant, you're judging the case for members of the public, you're trying to find where justice is and so on. Those are your guiding principles. You're making sure that the accused has a fair trial, number one, but you're not judging, you're not doing this case for the Court of Appeal. Now, in the case of no case submissions, change this line. The judge must decide upon the basis that the jury will draw inferences reasonably open to them and favorable to the prosecution. The fact that one reasonable inference is inconsistent with innocence does not mean that the case must be stopped. It is not the function of the judge to choose between inferences which are reasonably open to the jury. Those inferences that are to be drawn must be left for the jury to draw them, not for you to draw them. So once it's a case based wholly on circumstantial evidence and you're faced with a no case submission, you now have to ask yourself the question, what are the reasonable inferences to be drawn on the prosecution's case? Because at a no case submission, you are really determining whether there's a prima facie case made out against the accused for this case to progress. And in deciding that, you are going to have to say, well, these are the inferences that the prosecution that can be drawn from the prosecution's evidence, which will make out a case against the accused. If you find that the inferences are weak or there are no proper inferences to be drawn, then your decision may have to go the other way. But the case of Malcolm Maduro and the Queen, which I'm just putting up a quote on the slides there for you. And I find that this sets out your duty very, very carefully and simply. Where the case involves circumstantial evidence, the only concern of the judge is whether a reasonable jury could reach a conclusion of guilt on the evidence by drawing reasonable inferences from the evidence that is given at the trial. The question then is whether a reasonable jury may, on one view of the evidence, convict the accused. If so, even if another view of the circumstantial evidence throws up on the evidence that is consistent with innocence, then the judge should not withdraw the case from the jury. So is this a case in which there are reasonable inferences that can be drawn from the evidence in which the jury can conclude that the accused is guilty? If that's the case, then you do not stop the case, even if there are other inferences that may show that he might be innocent. Even so, you cannot. And why? Because now you will be getting into the arena. You'll be usurping the function of the jury because they will decide which inferences they accept and which they reject. And that's a question for them. So are there any questions? No case submissions. Anyone? I must be doing a really good job. I mean, people are not either a very good job or a very bad job because I mean, I thought I would get some feedback. Or must be very late and you must be very tired and so on.
You're doing a very good job, Justice Yorke. But I see one hand is up from Justice Goodtilipio.
Yes, Judge, please. I'm not hearing you. I think you're muted. Yeah.
Yes. Thank you. Can you hear me now?
Yes, I can.
Yes.
Yes.
Right. Thank you very much for your presentation, Justice Yorke Sonhun. I hope I got your name correct.
Suhan. Yes.
Suhan. Yes.
Yes.
My apologies. I was just wondering, you did suggest that this jurisdiction now has appeals from the decision of the judge to uphold a no case submission and or not to uphold a no case submission. So, and that decision I think would be given orally. So how does the Court of Appeal look at that without reasons being stated on paper?
Well, it's read into the record.
Okay.
It's read into the record. So we look at the record to see what you said and if you apply the principles correctly. Yes.
Okay, I understand. I was merely wondering whether it was so the judge has to anyway give reasons, a detailed analysis, even though it is an oral submission, an oral order.
Well, sufficient reasons, and surely it would not be as detailed as if you're writing it out, but a skeletal kind of approach, so that at least the counsel and the accused knows why it is the judge turned down the submission.
Right. Thank you. That was very helpful, because I did a case in Sri Lanka just as a matter of interest about 2 years ago, not as a judge, but as counsel. It was a very important case where the challenge was, it was a constitutional challenge where it was a court martial and a very senior naval officer was challenging the right of a court martial, because the court martial, as you know, doesn't have a jury system. It's three senior officers who sit as a panel of judges. And so the question was this question of the right to give reasons. And so the Sri Lankan Supreme Court, which is the apex court of Sri Lanka, went into this matter, looked at all the UK authorities and authorities around the world, and came to the finding that in a court martial there was no reason, there was no obligation in law to give right to reasons, but however, some form of reasoning had to be there. So it was in that context that I wanted to ask this question as to the no submission matter as well. So thank you very much for your explanation.
Sure, no problem. Any other questions?
Just as a follow-up to that, I am aware that sometimes in no case submissions, the judges would actually give a short written ruling. And if their lawyer is involved in the matter, they can give a written ruling, or as you said, just appeal to, and it can be read into the record.
Yes.
But one comment I wanted to caution the judges about is a situation where you have unrepresented accused persons. And in Belize, we don't have the concept of public defender. In my view, that would place more responsibility on the judges to hold the ring and be very careful. So you have to even be more careful with unrepresented accused persons. So there's no lawyers there to take the point about a no case submission. So the judge has to be even more vigilant in those circumstances.
Exactly, Chief Justice. That is just so important where a defendant appears unrepresented. The court now plays a double role, because the court has to make sure his rights are enforced. The court has to guide him along throughout the trial, and especially if the court, well, I don't expect he would make a no case submission, but this would be a good example of what we spoke of earlier, where the judge, in the interest of justice, might have to step in, depending on the nature of the evidence, the judge or the prosecutor, to stop the case if that is what is required.
Indeed.
Yes. Anyone else?
Just as a matter of interest.
Two hands are up.
Yes. Anyone? I see.
Justice Nanton was before me.
All right, Justice Nanton.
Thank you, Justice Pilgrim. I was going to give way to you if you prefer.
I just want to share very briefly an experience, because that actually happened. I had an attempted murder case with an unrepresented defendant, and he made a no case submission. Because, well, you have to, there's, as the Chief Justice alluded to, there's no system like legal aid as we do it in Trinidad, where virtually everyone gets a lawyer at the cost of the state. The Constitution of Belize provides that you have a right to an attorney at your own expense. So the unrepresented chap, you have to take him through all the procedures, evidence in chief, cross-examination, and at the end, I had to advise him on an okay submission, and he had to make one. And just as the Honorable Chief Justice said, I had to give a brief written, I gave a brief ruling orally in terms of his no-case submission. But it is important to have that in mind when you're treating with unrepresented defendant. Just want to share that observation.
Thank you for sharing, Judge. Justice Nanton?
Thank you. My comment was in relation, really, it's not a question, it's just more of a comment in relation to the dual roles again, as my colleague would have raised the reasons. If you are given written or oral reasons in a no-case submission, I imagine that ensuring that the judge chose that line in terms of what you're assessing at the no-case submission stage, which differs from what one would assess as a fact finder at the end of the trial. So even if the judge himself or herself has some doubts in terms of the credibility of a certain witness or the credit of the evidence or the prosecution's case, it must be important that that line is not crossed in terms of what you're really determining at the no-case stage, as opposed to what you will later determine if the case goes forward. So yes, my comment was just in terms of, well, I mean, I don't know whether you have any suggestions or comments to make in relation to that, but just that we really have to be clear about what we are assessing at the no-case stage, especially where we have that dual role as fact finder.
You could tell.
Yeah, yes, you have to be clear as to what you're doing. So what is your task? Your task is to determine whether there's a prima facie case made out against the accused. And you're going to determine that on the basis of the prosecution's evidence. This is why the submission is made at that stage, when the prosecution has completed leading all the evidence they intend to lead in the case. All right. And so the different tests you must apply. If it's a test, if the application, if the submission, is made on the basis that there's an essential element not proved, you have to go through the elements of the offense. You have to look at the evidence and see whether there's anything there. If there is on the face of it some evidence, then of course your no-case submission will fall by the way, because you must now leave it to the jury. If there is, then that's the first limb. If you decide to go on the second limb of the no-case submission, put it back again, Indira. Yes, and yes, I'm going to tell her that, Jim. The second limb, when we go to the second limb of the test, you're applying the second limb of the test. There is evidence, but it's weak. It's the inherent weaknesses, vagueness, inconsistencies, and so on. You have to ask yourself the question, the prosecution's evidence taken at its highest, is it such that the jury properly directed could not properly convict? If your answer to that question is yes, then there is no duty to stop the case. If, however, the strength or the weakness of the prosecution's case depends on the view you take of the reliability of the witnesses, and on any possible view, there's evidence which the jury could properly on which the jury could properly convict, then you have to reject the no-case submission. These principles apply equally to judge-alone trials as well as the jury trials. And as my colleague just reminded me, if you look at the case of Curla and George, you will see that part of the judgment addresses that. Your task as a judge alone and your task as a judge with a jury, and how you approach no-case submissions, wearing those two different hats, as it were. Does that help your question?
Yes, yes, it does. Thank you.
All right. Anybody
If
else?
if
One
I
more? Yeah, sure.
if I
Yeah.
could just add to what Justice Appeal Yorke Suhail said. As a trial judge, I found it very useful to keep the Galbraith principles in front of me and to look at the matter based on the different limbs and keep your ruling very tight. Because it could be
That's
a rule
right.
of thumb that once you get into very long things, you're stepping out of what you're required to do. The no-case
Yes.
submission ruling is usually very tight. It is easier if you were to keep the limbs in front of you and test it against the submissions. I found that very useful as a trial judge.
Yes. Keep it tight. That's a very, very important a point that the Chief Justice is making. Keep it tight, short, and brief. You know, I think it was Lord Devlin or Lord Diplock who said that brevity is the handmaiden of justice, but length and complexity its enemies. And I always found that to be quite a profound statement, because the more you write or the more you speak, is the more you put your foot in your mouth, as we say, and is the more you tie up things and confuse things. So, for
Exactly.
example, just a quick example, we take for example you're the trial judge and you're summing up the case to the jury, and the case continues for 2 or 3 days. You come today and you say, okay, I give you the general directions. You spend the whole day. You come back tomorrow and you say, no, let's pick up where we left off yesterday. And you begin to repeat everything you said the day before. And so you carry through to all the days. You're talking too much. Somewhere along the line, there will be inconsistencies. Somewhere along the line, your foot gets into your mouth and then trouble. So let's avoid the trouble. Okay, so let's move on now to summing up. I hope I'm okay with time. Going to move on as quickly as I can with this one. How much time I have? Here. Then, all right. Can you put right? Anybody putting up? Just 1 second. We're just trying to get the presentation on the screen.
Justice Suhan, we are not hearing you.
Apologies, they're not hearing. Where did you turn this off? Okay, you turn it off?
We're hearing you now, just appears
You
to
hear
one.
it? Okay, good, thanks. Yeah, so I'm saying that you have to consider the audience and the purpose. Are you summing up for the Court of Appeal? Now, one or two people seem quite concerned about the Court of Appeal, right? But they're the last people you should think about. We're really nice people, aren't we? Mr. Pilgrim, aren't we nice people? Chief Justice, we're nice people.
In my experience, yes.
Yes. So they're really the last people you should be thinking about. You want to get it right at all costs. And because that's the audience for which you're summing up, your approach certainly will be focused more on making sure these legal principles get across correctly. Are you summing up to the jury panel? You want to make sure they're properly informed, properly instructed. You want to explain it to the lowest perceived person that these are the principles and this is how your approach should be. Are you summing up to individual juror or jurors, the people, the man on the street, the people, as we say in Trinidad, who come up to town in the water taxi or in the maxi taxi? Are we summing up for members of the public, John Public? The people in the audience, the ones who visit the courthouse regularly, who have no business, but who want to participate in everybody else's business? Who are we summing up for? You see, the target audience will determine the language we use, the degree of it, the explanation we give, the amount of eye contact we make, whether we pause, whether we monitor, whether we repeat. Our whole approach and our whole summation will factor in those principles. What about our communication style? Again, that too will be determined by our target audience. If we summon up for the Court of Appeal, next slide, please. If we summing up for the Court of Appeal, then we might be just happy to read the text because we don't want to say a wrong word. A simple word like not could change the whole meaning of what you want to convey. So you want to read it right. Or you may think, if you're summing up for the jurors, that speaking extempore after glancing at your notes might be the best thing, and you glance up and you glance down at them. That might be the right thing to do. Or you can read from your text and then you stop and you give all these interspersed explanations about what you have just read. If you're addressing the public and the media is there, you want to make sure you pronounce your words properly, which you should do in any event. You want to make sure that you're making sense. You want to make sure that the public is impressed. And so how you approach your summation will depend on all these factors. What about your own communication style? Your own communication factors, the kind of body language you use, the eye contact, whether you can control your personal idiosyncrasies, whether you have a relaxed posture when you're speaking to the jurors. All of that, the jurors are looking on and they're observing, and these things impact. What about your speech and your language? Is it clear, concise? Are you repeating yourself over and over? What about your tone and your volume? Are you using simple language or complicated language? Are the jurors looking on and paying attention? Are you monitoring them? Are you noticing that the last juror, number 12, has been asleep for the past 15 minutes that you are speaking? Have you seen them rolling their eyes up in the ceiling? Have you seen them touching each other? Have you seen them looking a bit disgusted and frustrated? Do you think that they look like they need further explanation, that you're actually reaching them? All these are factors that are very, very important. And so before you begin to put your actual summation together, sit down for a moment, consider who your target audience is and what your approach is going to be. I did a trial once while I was at the bar in which the juror stoops right through defense counsel's address. I mean, we had to move the court to try to abort the trial because it was just so obvious that this juror was adverse to anything that we were seeing. I've done other trials in which the one of the members of the jury, as they were parting, as they were leaving for the day, got up and gave me a thumbs up, and the prosecution saw, and well, that was the end of it too. Another trial in which the juror fell asleep and almost knocked over the person next to him because we know we're a little cramped in the jury box. So we have to be observing. As one judge used to say, in a jury trial, I have to have eyes in front and eyes behind because I just have to see everything that's going on because everything is important in a jury trial. Now, when do you begin to sum up? Immediately after the counsel on both sides have completed their addresses, the next morning, or you give yourself a couple of days. If it is a long summation, are you going to take a break? Would that break depend on whether, on the length of it? So you're going to, stop quarter, a half, three-quarter, etc. Or you're going to stop at the issues, deal with self-defense, for example, take a break, come back and deal with diminished responsibility, perhaps. Or there are other circumstances that will determine when you are going to sum up the case, when you're going to begin and when you're going to end. Now, be very mindful that you don't want to send the jurors in the jury room to deliberate on a Friday evening when it is around 4 p.m. and the place is getting busy and buzzing. All the little bars around the courthouse full of people venting for the week, liming, their friends waiting on them somewhere, and you now putting them to go and lock away in a room for about 3 or 4 hours. So these two are important factors. You need to gauge the attention span of the jurors. You need to prepare yourself for complex issues. You need to watch the length of your summation. We at the Court of Appeal have seen some summations that are overly long, repetitive, and a danger of repeating your directions is that you can get them wrong the second time and the third time. So if you say it once and you say it correctly, close that door. Don't open it again unless the jurors ask for further directions. If it's likely to be a long summation, look out for the kind of distractions that you might have, the kind of pressure that you might feel, and try to, take in front, as we say in Trinidad, take in front and cater for those distractions. Give the jurors a little tea break. They can go and have a little refreshment, come back and be more focused. Next, we look at the preparation of the summing up. Preparation. And in your preparation, the first thing we would suggest is that you maintain a checklist. Make a list of things as the evidence unfolds that you need to address. And draft as the trial progresses. Draft, go back to your drafts. Allow time for mature deliberations. If something looks a little odd, discuss it with your colleagues. When you come to deal with the evidence, you don't have to give them the full blow. Witness number so-and-so, you heard Mr. X, who is from so-and-so place, who is a doctor, you heard him give evidence. If his profession and where he lives has nothing to do with it, leave it out. Only address the important details. Consult with counsel with respect to specific directions at an ENSO hearing, which you ought to have every time you hear a trial. Discuss what those directions are going to be. If the defense wants, for example, a direction of provocation, although they did not raise it, and there's evidence, you know that you have to give it. So discuss it with them. Use your bench book, because your bench book really is a guide that will help you to get your directions right. So these are some of the things that are involved in the preparation of your seminar. Let's go to the checklist itself. Your checklist is divided into 2 sections, or 3 maybe. General directions, specific directions, and the approach. So in your general directions, you will discuss the function of the judge and jury, the burden and standard of proof. If you have separate counts, you must tell the jury how to approach separate counts, how to treat accused separately. You must give the ingredients of the offense. If it's joint responsibility, you then must tell them how they must approach the enterprise, which they have heard that the defendants had embarked on when this killing occurred, for example. You must address the defenses, the alibi, the self-defense, accident, etc. So a summing up checklist is very, very important. Your specific directions, of course, will be your directions in relation to this particular case. What is the defense that has been raised? What is the prosecution saying? What is the prosecution not saying? Are there hostile witnesses in this case? What type of directions am I going to give? Are there depositions that have been introduced? What am I going to tell the jury about these depositions or absent witnesses? So those are specific directions you have to look out for. So you have your general directions, your specific directions, and then you have the approach. So for example, it's a case of murder, but manslaughter can emerge out of self-defense, out of provocation or diminished responsibility. So you need to tell the jurors, if you find, look at the evidence, consider the case for the accused. If you accept that he acted in self-defense, that he was and his approach was reasonable and necessary, and all these different things, and you find that he acted, so then you find him not guilty, go no further. But if you you have doubt about that, go on to consider provocation and so on. So you give them a step-by-step approach into how they're going to arrive at their verdict. So 3 stages of the summation. Then there's some special points, summing up points that I want to bring to your attention. And the first is that it's not necessary to be long and repetitive. I like the Chief Justice's words in respect to summations. Keep it tight. Keep it tight. The more you say is the more you open yourself to criticism. And so keep it tight. Where there's a special plea, that is, for example, if it's self-defense, remember to tell the jurors that the burden is on the prosecution to negative self-defense. If the issues are simple, if the case is short, then you don't need to review all the evidence. But always be careful to put the defense adequately. However weak, however foolish you may think the defense is, remember to put the defense adequately and to put it fairly. Next. Now, as a judge sitting with a jury, you're entitled to assist the jury with your comments on the facts of the case. But be careful not to cross the boundary. Your comments must be fair. They must not be adverse to the accused, and they must be correct. Don't comment on evidence which is not part of the case. Don't misquote evidence and comment on misquoted evidence. And the counsel under no circumstances must interrupt you during your summing up. Young judges, do not let them take advantage of you and interrupt you when you're doing your summation. Put your foot down and tell them that you will hear what they have to say when you are finished your summation. There's good authority for that in the case of Randall. So be brave and be bold. You all look so very young and so innocent, but I know that you're all very smart people, because I know this Chief Justice will only appoint smart people. Not only smart looking people, but smart people. And so be brave and be bold. Do not let someone, because he's senior counsel, come and run your court, come and tell you what to do. All right? Be brave and be bold. Do not let anyone intimidate you. So don't let them try to be interrupting you every time you try to proceed with a point. Okay? Tell them, Mr. So-and-so, thank you very much for wanting to make a point at this stage, but I will hear you at the end of my summation. When you finish, you put the jurors out and you say, Mr. X, what it is you have to say there now. If he tells you something of value, you take a little time, craft it, and you put it before the jury. All right? But a lot of times, it could only be a strategy to distract you so that you make a mistake. And their counsel, I know, in my time of practice and sitting on the trial court, who would do that kind of thing without a blink. So be very careful. Under no circumstances should you direct the jury to bring in a verdict of guilty. Under no circumstances. All right? So those are some important points that I thought I would leave with you. And then we want to come back a little bit to the skill or the art of summing up. And I have some very beautiful pictures here for you to look at. There are 3 people. Do you know these people? No? Why are you all looking like you never saw any of them before? No? All right. Well, you see, different people have different styles and they develop different skills. So our learned Chief Justice is not someone who in her speaking to you will shout and rant and wave. She will speak quietly but firmly. And when she's finished, you know that she means business. There are other people who might have a different style. I'm not saying any of the other 2 there. They too may also be quite gentle, but in their own different way. So what's the point I'm making? Develop your own style of summing up. Develop your own skill. You have come to the bench with a great measure of competence. And it's better if you came with a clean slate like Miss Nanton. A clean slate. You know why? Because you have nothing here that need to get rid of. It's harder to get rid of the habits and the skills that you have developed in the past, which are bad. And easier to put in good skills and good habits on a clean slate. You're able to write them out properly. And where they can have, be impressionable. So I urge you to be creative in your summing up. I always thought preparing a summing up was an exciting thing. There was always some point I wanted to make, that I felt excited about. That the attorneys, when I listened to their address, oh no, they didn't pick it up. And most times important points. I didn't just want to do it for my own pleasure, but because they were important points. And my challenge, as it will be yours, as it is yours, will always be to communicate and convey the message to the jurors that you want to convey, and to convey it simply and correctly without error. And so develop your own skills, develop your own style in communication. Use your creativity. And like any one of these wonderful people here who all have their own styles, you can develop your own. Now, when it comes to the law, how do you approach the law in your summation? I took out an excerpt from a case called Keene and Another, 2010 EWCA Crim 2514. I know it's long, but there are two things that this case points out as important in dealing with the law. The court was commenting on the judge below, who took his whole direction on self-defense from the Judicial Studies Board, which is the bench book. And they said nothing is wrong with that. So good, you have a guide, using it, nothing is wrong with that. But in using it, don't just use it carte blanche. Don't just use it because you want to just drop the law on the lap of the jurors. No, use it because first of all, bear in mind that the jury is not troubled with aspects of the general law which do not arise on the facts of the case and on the issues raised by the evidence. The jury cannot be troubled with anything that is irrelevant. And that's the point I want to make. Secondly, when necessary, give help about the way the law works when applied to the competing versions of the facts which they have to decide. So you have to assist the jury using the law, showing them how the law works with the competing version of facts. You don't just give them the law. And a lot of grounds of appeal come before us now where counsel complains, the appellants are complaining that the judge did not fully assist the jury on questions of law and fact. And when we look at the summations, true to form, the judge dropped the law without using it to analyze the evidence and to marshal the evidence for the advantage of the jurors. And so be very careful about that. Next, the law. So we have already spoken about the general directions, the specific directions, and I must add here, you must give a rational order of directions. All right, don't just have some order. You can decide whether you want to talk about the facts first, then you want to give them the general directions, or you want to start with the general directions first, then tell them what the case is about, and then spend the rest of the time marrying the law with the facts, marshalling the evidence, etc. You will decide on your order. Avoid unnecessary directions. All directions are not necessary. Sometimes you get a big, long direction on expert evidence, and all you have in the case is a cutlass. So whole big expert evidence about whether this is a dangerous weapon, the size of the blade, and all these things. That's not necessary. Leave it alone. And part of your biggest difficulty in the beginning, as it was mine, and I'm sure all my colleagues could vouch this, when you just start, you just don't know what to leave behind and what to take. Because you think to penalize it because that's important. But as you develop and as you grow, remember you're growing into this thing. As you grow, you're going to develop your own skills and it's going to come like nothing. It's going to come like second nature for you to decide these are relevant facts, these are not. Now, when we come to the evidence, when it comes to you dealing with the evidence, you need to summarize the respective cases. What is the case for the prosecution? what is the case for the defense. Now, long set of evidence doesn't necessarily mean a long summary. Similarly, a short case with a little bit of evidence doesn't necessarily mean it's going to be a short summary. Decide how you want to deal with it. Whether you're going to deal with the bit of the evidence and then intersperse the law in between, or you're going to deal with them separately. Be economical with your opinions, because again, you don't want to be out a turn and say something that will vitiate the entire trial that might prejudice the case for the accused. Now, when you summarize the case for each side, what you're doing, how I like to put it, is that you're telling a story. Everybody loves stories, and juries love stories. So make it interesting for them. You're telling them a story. The only thing I don't want you to say is once upon a time. Okay? You tell them, you know, some time ago in the month of June, around the 21st of June in 2006, the virtual complainant here, Miss So-and-so, said that something happened. And right away, everybody wants to know, what is this something? Is it the same thing that she told us? You're stirring up interest. You're keeping them awake. All right? So tell it like a story. And then when you move to the case for the defense, you say, but there's another side to what Miss X has said today, has said before you during the course of this trial. And that is the side of the defendant. He is saying, and like they like to say in Trinidad, I don't know if they say it in Belize, he is saying that I know nothing about what she is saying. She is lying on me. I don't know her. I've never seen her. And you can use her language. You don't have to stick to the Queen's English throughout, because you are communicating, and breaking down your language is also part of your communication skills. And so break it down, tell the story. The next thing that you must do, not only break down the evidence and tell them what it is, but that you must assist the jury. And I've alluded to this point already. You must break it down. And you must assist the jury. Distinct from making statements of law and reviewing the evidence, you must assist the jury. How do you assist the jury? By putting the evidence to the state and the accused in context. Identify specific bits of the evidence that may be significant and focus on the fact-finding function. In other words, I'm telling you to marshal the evidence. Put the case in context. Well, members of the jury, the prosecution is saying that this was a cold-blooded, deliberate attack on the victim. You heard the evidence of Inspector Billy. He took a gun. He pushed the deceased down. And in a very brutal manner, he fired a gun at his head. So you're putting it in context. So the state is saying this is a deliberate killing. On the other hand, you have heard the defendant, and his case is that he was nowhere there. He wasn't even there. Inspector Billy's lying on him. He knows nothing about this incident. And so that is putting the case in context. I'm sorry we don't have more time, but I'm trying to do this as quickly as I can. Please bear with me. And I'm trying to shorten it as best as I can. Now, you need also to assist the jury in their fact-finding duties. You need to tell them what the facts are, the facts in dispute, and what the facts not in dispute are. You need to distinguish between the meaning of credibility and reliability. You need to address the question of demeanor with the jurors. Tell them that not because a witness comes and gives the evidence perfectly, does it mean that he's speaking the truth? Not because a witness is not looking at you in the eye, does it mean that he's lying? He may just be shy. It might be his first time in the courtroom and he's not accustomed to the spotlight being on him and things like that. Explain what is an inconsistency, both internal inconsistency and an external inconsistency. Explain the value of consistencies. Explain what is the meaning of plausibility and how it can be applied to their fact-finding mission. Warn them about possible personal bias. So not because you see you see a man with a Rasta hairstyle charged for possession of marijuana for trafficking, does it mean that he's guilty just by the fact that Rastas are associated with smoking marijuana? You know, these are kind of these prejudices that you have to guard against. Not because the wife of the deceased comes to court to give evidence that she identified the body and she cries right through the thing. Must you be sympathetic to her? You have to judge the case and the evidence. And so any personal bias you need to address. If there's a motive to lie or motive to be truthful, you need to point that out to the jurors. And of course, you need to address the issue of bad character if it arises. So you need to assist the jury in two ways. One, in putting the case in context, and secondly, in focusing on the fact-finding task that is before them. And when you conclude in your summation, you address them on the possible verdicts that may arise from the evidence. You address them on multiple counts, that they must return a verdict in respect of each count. You tell them about counsel's comments and suggestions. If they are of value, you reiterate them. If you make any error, here's the opportunity for you to correct them. Now, members of the jury, I earlier told you so. But thinking it over, I need to tell you that I was wrong when I said so. And I so now would just ask you to forget what I told you, disabuse it from your minds, and I come out to tell you the correct thing, and I want you to pay attention, etc. If there are time limits for which a jury must bring in their verdict, remember to tell them what those time limits are. So this really is the approach on summons up. There are some other matters that I want to quickly address with you, matters arising out of the whole summing up issue. But so a lot depends on you and the kind of style you want to create. You are young and there's so many opportunities for you to carve your own way and to create your own style and to create your own skill. We had a very skillful judge here in Trinidad and Tobago years ago who could get any verdict he thought that was just to the case, especially a conviction. He used to use the body language and the voice, and he would state the prosecution's case, he would state the defense's case, and he would say something like this: Mr. Foreman, members of the jury, the accused is telling you that he was not there, that he does not know anything about this incident. You believe that? Anyway, it's all a matter for you. So he used to try to cover himself by saying it's a matter for you. But that communication was powerful. And from the time he asked them, you believe that? It's really telling them, don't believe that. So you too can carve, I'm not telling you to do that, but you too can carve your own skills, develop your own approach. And I'm sure it's going to be a very, very exciting experience. I'm really trying to get you excited about what you have to do. And because if you don't enjoy doing something, it's no point doing it, you know, because you're just suffering yourself. If you don't enjoy being a judge, well, pack up and come back home. You have to enjoy it. You have to like it. You must be willing to explore it. You must be able to find yourself in it, to be creative, create your own style. And you will go places if that is your approach to your work. So quickly, I want to look at some matters arising out of the summation process. Very quickly. First of all, we want to address written directions. I see that in your criminal bench book, you say it is not a practice in Belize to render written directions to the jury. I want to recommend that you should think about using written directions, because written directions are very helpful. Next slide. Written directions are very helpful, especially in matters of substantial complexity in long cases, in cases where several verdicts might be open to the jury. You need to do written directions, but never do written directions without first having consultation with counsel on both sides to find out whether they think it would be useful and helpful to the jurors. So written directions is not a matter of law. You're not bound to give it, but I have seen it be helpful, being very helpful to jurors in coming to their various decisions. In New South Wales, they have actually legislated on it that judges should give written guidance to the jurors at the discretion of the judge, of course. So these are the circumstances in which you will give it. You will give it in matters of substantial complexity. And so I've put up on the slides for you a quote again from the same case of Green. This was a case in relation to murder, manslaughter, robbery. It involved the principles in joint enterprise, self-defense, lies, rule against hearsay, dying declaration, good character. And nothing was reduced into writing. Can you imagine if we judges and lawyers don't understand some of those things? Some of us don't understand it, we just pretend that we do. But we don't understand these principles. And we put on a straight face and talk to the jurors as if we have it all covered. Haven't you ever had to pretend? I've had to pretend. You see? So this was a case involving all these things and no written directions. And the Court of Appeal in England and Wales was appalled. They said all these things, if the judge and ordinary and legal people with legal minds can't remember and apply, what you leave for these lay people? So they recommended in the case of Green that written directions be given. Now, what should be the content of written directions? Written directions should not be intended to replace your oral directions, but an addition to them. And you must take every care to ensure that written directions are accurate and without the possibility of misunderstanding. Do not try to orally elaborate what you have given them in writing, because we have had to turn down appeals simply because the two things are inconsistent. The written correct, correct to form. And as the people say here, correct is right. It's very accurate. But then the judge thought that the judge will give them, a little explanation. And that's where the judge went wrong. And everything turned old mass. We had to allow the appeal. Now, what are the benefits of some of written directions? It improves the jurors' comprehension, because a lot of them give them that. They are assumed to have common sense and they can read and understand. It reduces their deliberation time because they don't have to argue about what the judge said. It assists in resolving disputes between the jurors, and it helps to identify the issues in the case. And it would also help them to focus because once those issues are identified, they can now focus on those issues. We come now to route of verdict. Now, a route of verdict is different from a written direction. Clearly, the written direction has to do with the matters of law. The route to the verdict has to do with the approach to the jurors with respect to the different verdicts that might be open to them. And there are good illustrations everywhere. I sent you my slides, and you will see that I do have an example that if we had the time, I would have gone through with you. So a route to verdict is very, very important as well. Now, what about directions to retire? We was in Trinidad and Tobago some time ago. We had a problem because our legislation told the jury, asked the jury, words to the effect, do you wish to retire? And the Privy Council said, well, those words imply that there is no need for you to retire. It's like the judge who in his summation says to the jury, you believe that? When he really meant to say, don't believe that. And so if you ask a jury, do you wish to retire? Well, you're really telling them there's no need to retire. And so the Privy Council turned that around and suggested a different direction that goes like this. Members of the jury, the law requires that you now be given the option of either returning a verdict without retiring or retire to consider your verdict. The option is given to the jury in every case. What is your option? Is that what you do in Belize? Because we were searching and couldn't find any legislation or anything that says exactly what words should be said to the jury before they retire. Is that what you do? Is that how you put it? Anybody?
No, I've never seen any words. What I always do is invite them to retire and consider their verdict.
Okay. Well, that's good because you do a general thing. You may now retire and consider your verdict.
Yes.
Yes, excellent. So we have had to correct that situation here in Trinidad and Tobago. Now, late retirement. In the case of Holder and the state, the Privy Council said that late retirement of a jury in a capital case is undesirable. It's better to adjourn if you know that your summing up is going to take them to late hours. Don't keep them longer there because it will cause pressure on them to bring in a verdict, and that verdict may not be a just and fair verdict having regard to the evidence. And so a late retirement is not advised. Adjourn, let them come back fresh tomorrow, and then you let them then you let them retire, and so they can come back with a verdict, with looking at things with fresh eyes and well rested. Now, what about if the jury comes back? So you have 4 hours in the case of murder capital matters and 2 hours in the case of non-capital matters. What if the jury comes back to court before the expiration of the statutory time and say, look, we don't have a verdict, we're deadlocked? Then if the time has expired, you can deal with it in one way. But if the time has not expired, you must send them back until that 2-hour period is completed if it's a non-capital matter, or until that 4-hour period is completed if it is a capital matter. Send them back and tell them, Mr. Foreman, members of the jury, I'm afraid we cannot deal with your decision at this point. You need to go back and continue your deliberations. And when the time comes, the court will send for you. So you cannot take a verdict where a jury is deadlocked before the statutory time expires. What about if the jury comes back for further directions? Well, when the jury requires further directions, you get a message from the clerk or the marshal. You need to call the attorneys, call the counsel before you, let them know that the jury require certain directions, and get all your directions ready because you don't know what they're coming to ask, and you send for the jurors. When the jurors arrive, you tell the jurors, I understand that you need further directions. What are your difficulties? If they ask for assistance on the facts, well, then you tell them this, you just tell them what the evidence is. You do not help them to determine the facts, of course. You just remind them of what the evidence is. If it's a direction in law and you have already given that earlier direction, repeat it in its same form. Because if you go to transpose it into any other thing, it might not be correct. So this is why I say have all your directions ready. If you have to do a new direction, craft it so as to minimize any danger of confusion. If a note is sent to you, show the note to counsel. If the note discloses a division of opinion between the members of the jury, do not show it to counsel because the time has not expired and you still have to give them time to go back in and deliberate. If it's a non-capital matter, remember you can take a majority verdict. So you do not, if it's a division, you do not show it to counsel at that stage. Now, what happens after 4 hours and after the 2 hours? After the 4 hours and the 2 hours, if there's a deadlock, you ask the jurors, do you require more time? If they say yes, okay, you send them in, but you do not give them a time. You do not say, well, I'll give you an hour, 10. Go, let them go back and say, when you are ready, let me know. Because to give them time, the law has said that you'll be putting pressure on them and that verdict will have to be set aside. So you do not give them any more time. You can also admonish them to come to a verdict. And you do so in accordance with the principles in the case of Watson. We call it a Watson direction, where you tell them that experience has shown that jurors are able to agree in the end if they are given more time to consider their verdict. And for that reason, judges usually request juries to re-examine the matter on which they have disagreement and to make a further attempt to reach a verdict before they may be discharged. So in the light of what I've already said to you, I ask you to retire again and see whether you can reach a verdict. So that type of direction crafted in that way will not bring an allegation of any oppression or pressure to the jury in order to arrive at a verdict. If, however, when you send back for the jurors and they come back to court and they say they still cannot agree, and you say, okay, retrial order, as happened in one case, the case of Peter Holder and others. And then the jurors say, but judge, we didn't finish, we just needed some more time. And the judge says, well, all right, go on back. And so they come back down with a verdict of guilty. That verdict will be set aside. Because from the time the judge made the order for the retrial, the whole process has come to an end. And the judge is functus. He has no authority. That's the end of the trial. And so he cannot send the jurors in once he's made that final order for the retrial. So one of your cases, the case of August, number 7 of 2014, take a look at it. It deals, it sets out dealing with a deadlock and the words used, we don't have time to go into them. And this was upheld by the Court of Appeal as the proper approach. Now let's take a quick look at the verdicts. You may have no verdicts, in which case you would have to order a retrial. But in capital cases, you want a unanimous trial. And if it's a lesser verdict of manslaughter, you can also accept a unanimous verdict. If it's a majority, if it's a non-capital case, you can accept a majority verdict. And in some instances, reasons are required for verdicts. So the verdict must be clear and precise, and care must be taken in asking the jurors exactly what their verdicts are. In cases where there are options of murder and manslaughter, and they come back and they say guilty, you must ask them guilty on what? Was it on the charge of manslaughter or the charge of murder? If there are multiple counts, remember that each count requires a verdict. If there are multiple defendants, you must give multiple verdicts in respect of multiple defendants. So there must be a verdict in respect of each defendant and in respect of each count. Now, what exactly is a unanimous verdict? A unanimous verdict has been something that the court has had to adjudicate on several occasions. So in one case, it was said, you cannot, assuming that you retire to consider your verdict, return to give your verdict unless 4 hours have passed and unless all of you have agreed upon a verdict one way or the other. And the judge says, that is the meaning of unanimous. Is that a correct meaning of unanimous? Anyone? You or nay? All of you must agree one way or the other. It might be, but then the judge does not go on to tell them that you have a right to disagree. Remember, the jurors have a right not to agree with each other because they swear to an oath that they will return a true verdict in accordance with the evidence. And that true verdict must be based on the evidence. And if they find that, their consciences and everything, putting everything in the mix, that they cannot give a verdict like the others are doing, then that particular juror or jurors can and are entitled to disagree. So murder require unanimous verdicts. Unless you have a unanimous verdict in a case of murder, then it really amounts to no verdict. There are several cases that you will see on the slides that I've sent to you that would set out exactly what a unanimous verdict is and is not. We spoke about the deadlock. We spoke about what's in direction. We go on now to majority verdicts. Right, so you cannot have a majority verdict in a capital case, but in a murder case where manslaughter is an option, you can find the defendant not guilty of murder, but you can find him guilty of manslaughter. If he's not guilty of murder, the court has a discretion to accept a majority verdict on the question of manslaughter. And that majority, according to Section 21(1) of your Jury Act, says that it must be 11-1 or 10-12. Anything less than that cannot be accepted as a majority verdict. And a new trial will have to be ordered. In non-capital matters, your Jury Act Section 28 gives the court a discretion to accept 8-1 or 7-2 as a majority verdict. Now, taking a majority verdict can be a little technical because you don't want the jurors to split out the verdict. You just want to know in what numbers are they divided, how they are divided. And so when you ask that question, you have to admonish the foreperson to listen very carefully to what I'm asking you. Is the defendant guilty or is not guilty? That is not what you want to know at this stage. Mr. Foreman, I understand that you all are at a deadlock, and I want to know how you are divided. So without telling me in whose favor the majority lies, how are you divided? And then he will say 11-1 or 10-2. Then you accept your majority verdict in the case of manslaughter, or 8-1 or 7-2 in the case of a non-capital matter. Anything less than that, you will now have to say, you have to take, you have to order a retrial. Now, let's go on to alternative verdicts. Now, whether an alternative verdict is available should be dealt with prior to closing addresses in order to avoid unfairness to the defense. So if it's a murder case and they ran a complete self-defense, they're looking for a full acquittal, but provocation arises and manslaughter will be open as an alternative verdict, and the judge intends to address it as he should, as is his duty, then the court must at the end so hearing discuss this with counsel. And when you direct them on alternative verdicts, you must warn them that they must not bring in an alternative verdict as a means of compromise, but it must be something which they truly accept arises on the evidence. So be careful about that. Inconsistent and ambiguous verdicts. Sometimes the jury would return and give a verdict that is inconsistent or ambiguous. And so you, the court, you, the judge, it's your duty to clear it up. Don't just stand by and say, well, that's what he said. What are you going to do? No, you have the responsibility to make sure that you clarify it. So in the case of Rampasad and Singh and others, a case coming out of our Court of Appeal, we held in that the verdict was both inconsistent and ambiguous. So the judge directed the jury on the question of felony murder. And she asked them when they came back, what is the basis for their verdict? Is it on the felony murder rule? And the juror says, I think so, you know. I believe so. I think we applied that rule you told us, you know. And the judge accepted the verdict. The judge ought not to have accepted that because the whole thing was ambiguous. It was unclear. And so the judge ought to have dug deeper and says, well, no. I need to know. I give you certain directions, X, Y, and Z. You had a route to verdict. Tell me. So that was held to be inconsistent, ambiguous, and so look out for it. Now, given reasons for a verdict is something that we really currently don't have legislative power to do. But judges need to explore their own, to explore it and to determine whether the particular circumstances of the case require it. And so use your common sense, use your experience, discuss it with senior judges if you are not sure whether you should ask the question. Because sometimes a verdict may be one or a number of other things. So you give a direction on murder. So it could be a verdict on murder. There's manslaughter, but manslaughter arises by way of unlawful act, manslaughter. It arises by way of diminished responsibility. It arises by way of provocation. And believe it or not, all those are open on the evidence. What are you to do? Apart from doing a route to verdict, it is suggested that in those types of cases which were considered to be exceptional cases, the jury should be told that when you come back, we just want to know if you come by way of manslaughter on any one of these four things, we need to know which one. Why? Because it might be important to the question of sentence. In the case of Isaacs, which is also on the slides for your attention, you will see that it was suggested that judges should be told that the judge that the jurors should be told that the judge would be asking what is the basis for your verdict. So the court never goes behind the jury to find out how they arrive at the verdict or what they did, but in cases where it might be important. So one school of thought is that you should ask them. The next school of thought say, no, don't ask them anything. We cannot go behind that. We are staying our ground and so on. But what you can do is that you now must assess the evidence and figure out how they arrive at the verdict in order to decide how you're going to pass your sentence. Now things are changing, things are evolving. The law is not operating in the same way as it did 800 years ago. Things have changed. So I don't know, with the second school of thought, how you're going to read the minds of all these people to figure out exactly how to craft your sentencing on that
That's
basis.
one.
So,
May I interrupt you briefly?
yeah, sure.
I'm looking at the time because we have another speaker waiting.
Okay.
Justice.
You know, I'm on my last point. I'm actually on my last point.
Oh, very well. Okay.
Yeah, I
Proceed.
really apologize. I tell you that we really need more time to do these things because there's some exercises and sort of like to have done, but another time.
I understand.
So yes, so the reasons for the verdict, you can ask for reasons in the appropriate case. In the appropriate case, you can ask whether you accept one school of thought or the other, but if you find the case is appropriate, then it's always up to your discretion. And finally, discharging the jury. You must discharge them immediately upon their verdict. But you cannot call them back to ask them anything. Once they have gone, that's the end of the story. You cannot call them to say, well, I forgot to ask you this or I forgot to ask you that. No, that's the end of it. They are discharged and they too now become functors. And so I thank you so much for your patience and your kind attention. All this afternoon, you've had to put up with my voice and with, my talking to you. I hope I didn't put you to sleep. I hope of what I've been able to impart was helpful. Sorry we didn't have more time because there are a lot more exciting things about summing up that we could have done as a group and some little exercises and so on, but another time. All right. So thank you again, Chief Justice, for giving me this awesome opportunity. And I want to take this opportunity as well to wish all these young, brave, bright-eyed, bushy-tailed, good-looking people the very best in judging, the very best, especially as judge alone in criminal trials and judge with a jury. Wishing you every good success and God's blessings as you perform your task. Thank you again.
Thank you, Judge, for your time you spent with us, the research you did, and the package that you put together for the benefit. As I said, it's not only for the new judges, but the old judges as well. We thank you.
Just
And
briefly, Justice Combach, with your indulgence, say special thanks to Justice Suhan for her very enlightening presentations. It was a sort of refresher for me, and I'm sure the young bright judges benefited immensely. And we will definitely take you up on the offer to have you back for some other sessions. Thank you very kindly, Justice Suhan. Thank you.
Thank you.
Okay. We now invite Honorable Justice Trevor Ward, Justice of Appeal from the Eastern Caribbean Supreme Court, to give us his presentation on the subject of judicial sentencing.
Yes. Thank you very much, Justice Combach, my erstwhile colleague on the OEC, Eastern Caribbean Supreme Court. Thank you very much, Chief Justice, for the kind invitation to present at this forum. I too enjoyed the stimulating presentation by Justice Alice Yorke Suhan, a judge before whom I cut my prosecutorial teeth back in Trinidad and Tobago some years ago. So I would have had firsthand the opportunity to learn at her feet. So we come to sentencing, often said to be perhaps the most difficult part of the criminal trial. And I don't know if you share that view based on your experiences to date. But what do you hope to accomplish this evening in the time? And I promise not to tax your patience too much, is at least to suggest to you an approach towards constructing your sentences, touching a bit on the important and core principles, and looking at some of those features and principles of sentencing that you tend to engage on a day-to-day basis in the criminal courts. The focus may be somewhat tilted towards circumstances where it may be appropriate to impose custodial sentences, because you'll find that that usually is what engages the public's attention most. People are always out there scrutinizing what sort of sentences the courts are passing. Are they giving slaps on the wrist? What have you? And while you're going to be mindful of the public's interest in seeing that justice is done, of course, you're not going to go the other extreme and try to appease public sentiment and give a sentence that does not meet the justice of the case. But while that might be our focus this evening, you'd be aware, of course, that there are other non-custodial dispositions, and often provided by statute what type of alternative disposition available: fines, suspended sentences. Some places have probation orders, community service orders, etc. So you should be aware of those. So it's always helpful to start with the cardinal principles of sentencing. Any person, any judge who is embarking on the task of sentences should have at the back of their mind these principles, these aims. The first and obvious one, of course, is that, as I indicated earlier, it's meant to mete out an appropriate form of punishment having regard to the circumstances of a case. It must be just to meet the circumstances of the case. And you will get to the stage of sentencing either because a guilty plea has been entered or after a trial. In either case, the principles apply. Another aim, of course, is to deter like-minded persons from committing offenses, and to ensure, of course, that that particular individual, you deter that person from committing further offenses himself. You also seek to protect society from those persons whose participation, their rate of participation in criminal activities is high, or we can view them as recidivists. But critically as well is the principle or the aim of rehabilitation. And this is especially important when we are dealing with young offenders, because the whole aim must be that where a person shows or has some realistic prospect of being rehabilitated, that should be a critical aim in the sentencing process. So that you should try to shape the sentence in such a way that at the end of it, that person can be reintegrated productively into the society. It's not always the case that you've got to lock up people and throw away the keys. That's a misconception. You shape the sentence to suit the circumstances to meet the justice of the case for both sides, the victim, society, the defendant, all sides. Now, a critical stage before you actually get onto crafting your sentence, in my view, is what I call the sentence hearing. Best practice really requires you, and that would be my advice to you, that you always have a sentence hearing. You get that is where you will have your mitigation, your plea